You're not even versed on this stuff. I got people that come in here that are way better versed on this stuff than you are. You must have just became a sovereign citizen. Is that what you're alleging? You're a sovereign citizen?
Sir.
What'd you say?
This court system operates like a bank.
Okay, it doesn't, ma'am. This
It
court system
operates.
doesn't operate like
Yes,
a bank in any way whatsoever.
Hold on, let me finish.
No, I'm not gonna let you finish that
Okay.
particular statement.
I would like the court to show me a contract where that we have with each other that signed with both our red signature before I move on to prove that you have any jurisdiction over me.
Are the defendants utilizing rhetoric of what would typically be called a sovereign citizen movement,
No.
including raising nonsensical
No.
challenges
No.
and attempting to
187-02-651, SP 187-6119, counts 1 and counts 2, SP 187-61221. Appearance for the record, please.
Tiara Harris, on behalf of Mr. Griggsby, please state your name for the record. You do not want counsel. Understood. I withdraw my appearance, Your Honor.
All right, Mr. Griggsby, state your name for the record, please.
For the record, I am in special appearance for Contrail Eugene Griggsby Jr.
All right, day is date and time. Good morning to you. Day is date and time set for a show cause. I'll enter a not guilty plea on your behalf. I'll give you a $0 bond. What do you want to do? Do you want to speak to the city attorney and see if you can work it out? Or you want a trial date, sir?
I would like to. I guess I would like to. I would like to speak to an attorney because I have some demands that I sent to you, and I don't know if you got, but I will have some demands I would like to give to the court before anything else move on.
Okay. So you want to speak with the city attorney? I'm gonna put you in the breakout room with the city attorney. Why don't you go in the city attorney and let they're in there talking. I'm gonna put you in a different breakout room. Join the room, speak with the city attorney, see if you can work it out.
Can I ask you a question?
You may.
I had emailed you some documents and sent some documents. Did you receive the documents that I emailed?
I do not think I have those offhand.
Okay.
It may be in another stack of mail somewhere else in my chamber. What are the documents you sent me, sir?
I sent from my email address, onemanarmy936@icloud.com.
So wait a minute, let me see. One Man Army, is that spelled out?
Yes. ONEMANARM.
Oh, you just sent that stuff today?
Yes.
All right, I'm gonna put this in your file.
Okay, thank you.
Affidavit of status.
Yeah, I had sent it in the mail as well, but I didn't think it would have come in time. That's why I just resent it today.
All right. Act of expatriation and oath of allegiance and deed of reconveyance.
Yeah.
All right. We'll just put it all in this file.
About to join the room now.
Go to the room, wait on Miss Horn. I'm gonna see if she joins that room. We'll pass the matter. Let's go back on the record with Mr. Griggsby. Mr. Griggsby, I've given you an opportunity to speak to counsel. What do you want to do? What do you want to do, Mr. Griggsby?
I would like to the court to. I would like the court to show me a contract where that we have with each other that signed with both our red signature before I move on to prove that you have any jurisdiction over me.
All right, I'm not going to show you anything. It's not my job to show you anything. You read the court rules. and go by the court rules. If you don't know the court rules, then hire an attorney and they can help you with the court rules. But we're not going through all of that. Do you
And
want
Your
a
Honor,
trial?
I did
Let me ask you, do you want a trial date or you want to take a deal? Did you give him a deal?
I did offer that, but he didn't want to go further without the information he just presented to the court. I did ask him as far as any written documentation, and he did as to whether he had the complaint / the ticket charging document. He did say he stated that he had that. I asked him if we can move forward with a trial, and that way the officer can be here for testimony. The offer for the record, Your Honor, and that's one of the things I wanted to do, would be disorderly conduct, amended from to entering owner's property, vacant property without permission.
I will send you and forward what he just sent the court. Well, he sent it earlier today. And what was that sent under? What was that name sent under?
One Man Army 936 at iCloud.
Oh, here it is. I'm gonna forward this to you, Ms. Horn. So you'll have it.
Thank you, Your Honor.
Why don't I have your email address?
I think you do, Your Honor. I can send you an email from here. I generally also send emails to you with the offers, Your Honor. Let's see.
Yeah, well, you should. I should have it, right?
Correct.
It's not coming up for some reason. That's correct. Oh, maybe, I don't know why it's not coming up.
There you go, Your Honor.
Oh, I know. I thought it said Tom Horn. I was thinking, hey, that's just.
Yeah, I can't stand that nickname, the name they gave me for my email.
That's why I wasn't. All right, this is one email he sent me. This is another email he sent me. I think some of it is the same, but you can go and we put the stuff in the file. And I think that's it.
Okay, thank you, Your Honor. Received.
All right, so you've got the offer. You don't want the offer. You want a trial date. You want a jury.
This is where the strategy quietly collapses. The defendant believes invoking special appearance and contract language creates leverage. But in criminal court, jurisdiction isn't negotiated, it's established by law. That gap between belief and reality turns what feels like control into a direct path toward trial risk.
Trial, we're just going to schedule a jury trial for this because if you know, this is a situation where you are going to try to move on. Sounds like you're trying to move on your own rules and you got to go by the court rules. And that special appearance and that kind of stuff, I just don't understand it.
And Your Honor, in response, I did advise him that as a person without a law license in Michigan, you can't represent someone else. So if he's claiming not to be the person who's been charged with the document, he can't represent that person as a special appearance. That would be unauthorized practice of law, in my opinion.
Yeah, I mean, we're just not going to go down that rabbit hole either. We're just going to do a jury trial date, sir. If you don't want to take the offer, you will admit that Ms. Horn gave you an offer, right? I'm muting you, Ms. Lyons. You got some background noise. You will admit Ms. Horn gave you an offer, correct?
Correct. And can I ask a question? You said that you did give my my affidavit or rebuttal, right?
I got all that stuff. I put it in the file.
Right. Can I that be put up? Can that be put on a record? I would like that to be put on a record.
On the record, I put it in your file.
All right, I'm just making sure.
Oh, you gotta answer my question now. What about what do you want to? I'm going to give you a jury trial. Give me jury trial date, please.
And Your Honor, for the record, if he's not accepting jurisdiction, I'm not sure why he's sending responses or even in court today.
I don't know. I don't know. I know we have some other people. Everybody's gonna get their time to be heard, so we'll get him a jury. Yeah, do you mean?
Because it's been more than 15 days, and like I said, the paperwork, I had mailed it out, but I wasn't sure that it got to y'all today. That's why I made sure I hear just for that we wouldn't, like I wouldn't be showed as a didn't come. That's basically why I make sure.
I know. So what Ms. Horn is saying, put your appearance on the record, please, Ms. Horn.
Yes, Your Honor. Tamika Horn on behalf of the people, P70303.
So what Ms. Horn is saying is that you're acknowledging that you're Contrail Eugene Griggsby, right?
I'm acknowledging that I'm acknowledging that I am. Let me show you. I reject the assumption that I am a paper lunatic.
You're not even versed on this stuff. I got people that come in here that are way better versed on this stuff than you are. You must have just became a sovereign citizen. Is that what you're alleging? You're a sovereign citizen?
No, sir. No, sir.
Okay, so what is your basis for all this special appearance and things like that?
That I need some type of contract for you that say you to have power to a judge to rule over me. I need some. I'm not a citizen of the state.
You're not a citizen of the state?
No, I'm not a citizen of the state. So
you're your own sovereign. You're your own sovereign citizen, right?
No, I'm not. That's an oxymoron. No, I'm not an oxymoron. No, that's an oxymoron. A sovereign citizen. It can't be because a citizen give the state or the feds make you a ward, and I'm not. I am grown. I am the living being. Like I said, that's why I sent you that's why I sent you what I sent you, my rebuttals, because I reject the presumption that in attendance.
Jury trial date? What is that?
Applies to any jurisdiction, observe all rights and waive none.
Let me make sure that's not a Wednesday.
I challenge the presumption that the members of the private bar guild acting as judges, prosecutors, or magistrates are immune to personal accountability for their actions. I demand proof of their immunity and accountability under the law. I reject that.
All right. Here's what we're gonna do. We're gonna give you a day in court. If you want us to appoint an attorney so they can help you with procedure, we can do that. No, so we're gonna order a jury. Ms. Horn, I'm gonna set a final pretrial date, and I need all parties to appear on the final pretrial date. You don't have to appear in person. But
Yes.
I need to have the officers here to make sure that we're gonna go on this. And then that's gonna be May the 4th at 8:30, final pretrial. And then May the 5th, Cinco de Mayo, we're gonna have a jury trial. That's gonna be in person. So Mr. Griggsby, you can come by Zoom on May the 4th, 2026 at 8:30. I want all parties to appear. That court date is really set to make sure that Ms. Horn has her officers together and that Ms. Horn is ready to go. Ms. Horn, if those officers do not appear on April the 4th, we're going to dismiss the cases. If they're here, we're going to have a jury trial on May the 5th, 2026. All parties must appear in person.
So noted, Your Honor. Thank you.
All right. Anything else, Mr. Griggs?
No, sir. Enjoy the rest of your day.
Very good. Best of luck to you. Have a very good rest of your day.
Well.
Thank you, Your Honor.
You're welcome.
Do have a request for pro se. She would like to represent herself in this matter. So I'd like to conduct a Feretta hearing. Ms. Butler, please raise your hand to be sworn. Do you swear or affirm under penalty of perjury to tell the whole truth and nothing but the truth?
Yes.
Okay, thank you. All right. Are you under the influence of any alcohol or drugs today?
No.
All right. Have we set a trial on your case? I was going to get back in the calendar here. Get back in the file, rather. I closed it.
We did, Your Honor.
Oh, that's right. Yeah, we set a trial already. Your trial set for August the 18th and 19th. And you've indicated you want to represent yourself. Did you have a chance to review the pro se waiver rights form I presented you in open court?
I looked at it a little bit.
Did you sign off on that?
No, I did not sign off on it yet.
Okay. Would you like to have more time to review it before you sign it?
Yes. Can I get the second page, please? Because I have written on the back of it. You have
I'll give you
you
a
have
whole
a
new one.
spare. I'm just gonna give me a whole new one. Can I also address something? You just let me know when I can.
Oh, go ahead.
When we spoke earlier about the document that was submitted, I just want to inform you that the head clerk is aware of it. Since May 11th, they've been working with me, providing me all the accounting. What you just gotten just now, I think one of your staff did not follow the correct procedures. So I was going to let you know that my estate has not been abandoned. I also want to let you know that I did not appoint anyone to administrate my estate. So for that being said, I'm coming here with honor, clean hands, and no controversy. I do not want to argue about anything. I just want it to be settled, closed, and gone.
Okay, ma'am. Anything else?
When you do present another date for me to come in, would I be able to talk about this matter? How this all led up to, because I really never got a chance to even speak to no one. I've been
Ma'am, that's what the
silent.
jury trial's for, okay? All the facts and circumstances related to the case, the state's evidence, everything of that nature would come out during the jury trial. So I need to go through this Feretta hearing with you, ma'am.
Okay,
You've indicated you want to represent yourself at trial. You have a right to do that, just as you have a right to have counsel present and have a court-appointed counsel if you can't afford one. But before I make that decision final, I want to make sure you understand what you'll be giving up. You understand you may have a number of defenses which apply to your case, which an attorney is trained to know. Do you understand that?
I comprehend.
Okay. And do you realize that if you were convicted of the offense in this case, that you're facing a possible penalty of 2 level 6 felonies? So each one of those would carry between 6 months to 2.5 years in prison. So the total combined penalty could be 1 year to 5 years in prison. Do you understand that that's the possible penalty?
I comprehend that as well.
You realize there are factors the court can consider in increasing your sentence within that range or in decreasing your sentence within that range, and that those are called mitigating and aggravating circumstances, and that a trained attorney knows how to identify those and present those to the court?
I comprehend that.
Okay. Attorneys have developed certain skills in investigating your case, interrogating witnesses, and finding favorable witnesses and obtaining their testimony. They can explain the charges and any lesser included offenses to you. They can gather documents and other kinds of written evidence. They can prepare and file motions before trial, such as motions for a speedy trial, motions for discovery, motions to keep unfavorable information from being received as evidence. They know how to examine and cross-examine witnesses at trial. They can recognize objectionable and unfavorable evidence and promptly object to its use. They can present favorable sentencing information and attack unfavorable sentencing information. At a jury trial, they can present favorable opening and closing statements, prepare appropriate written jury instructions, and select a jury. They have the training, knowledge, and skill at properly preserving the record of the case for purposes of an appeal. An attorney can also evaluate the strengths or weaknesses of the case against you and give you expert advice on whether you should attempt to seek a plea agreement with the state, which may result in the dismissal of some of the charges and a recommendation for a favorable sentence in return for your plea of guilty. Do you understand all that?
I comprehend it.
Okay. You must understand if you decide not to have an attorney, you will not receive any special treatment with your defense. You have to follow the same rules and procedures in your case as an attorney would have to do. Do you understand that?
Yes, I comprehend that, so.
Okay, so you filed these documents with the court, and these documents make statements about an Office of Executor Observations,
Mhm.
findings regarding Porter County Superior Court interaction with Tiara Butler. You talk about final order to settle and close,
Yes.
different things like this. And then
Yes.
there's like a recitation of chronology, different things of that nature. And a few minutes ago, you mentioned something about how the clerk's office is helping you like settle your accounts and different things of that nature. You understand that those aren't themes or processes that are part of a criminal court proceeding?
Well, I had did some research on my case, and I noticed that I had in a
Oh,
high,
that's not the question I asked.
no,
I think you misunderstood the question.
it's not criminal. It's not criminal.
Oh, you're here in a criminal proceeding. Do you understand
Yes,
that?
yes, I am in a criminal proceeding, but like I've been trying to explain, ever since when I had,
Well, I need you to answer the question I asked you.
Okay.
Okay, which was whether you understand that these documents and things that you follow with the clerk's office, what's the receipt date on this?
it should be April 16th or 15th.
April 16th it was received, so just yesterday.
Mhm.
That these aren't criminal matters that you followed with the court?
Mhm. Those are criminal matters, the violations that have been held against me. Yes, that's a lot of
You
violations.
understand they're not, though. I mean, these aren't things of a criminal nature that would be part of this criminal case.
Well, you saying what I just found is not what criminal?
This
Explain a little bit
document,
clearer.
these papers seem to indicate that you're trying to proceed in equity or under
Yeah,
some
that's
sort of
what
a
it is.
pseudo-legal jargon, some type of a,
Is we in the Article Court 3 right now?
say again?
Are we in the Article Court 3 right now?
I don't understand what you mean. This is the
Means
Superior
that,
Court of Porter County.
okay, so we basically still in the same court as administrator. So you're basically trying to administrate a mistake. What I was letting you know.
Okay, Ms. Butler, you understand that these administrative things that you're talking about aren't part of this court proceeding?
I know, I'm aware of that. I was talking to myself, but what I'm saying is I have done some research, okay? And I actually wanted to address it. And I'm not getting no assistance with the public defender, okay?
What are you trying to address, ma'am?
My innocence of the matter, and also the violations, the due process, the unverified information, the lying, the evaluation. I've been forced to be drugged without a cell hearing. My evidence that was held from me when the what's his name? Jeffrey Clymer had ordered the prosecutor to meet me in private to see my documents. I mean, the evidence held against me, and he refused to present them to me. That's a brandy violation because it worked in my favor when I first got it. Then also
Ms.
on the
Butler,
record.
I'm trying to get you through this
Hold on.
Feretta hearing.
I know,
okay?
but you asked me, and I'm trying to explain the violations, okay?
Right, but those aren't violations that are
They are,
part of this court proceeding.
now on this court
If you
proceeding,
have something that you plan to file related to that, it has to be filed through your attorney because you
And
still have attorney.
I did that too. You know what he did?
I don't know, ma'am.
Ignored me.
What you have filed through the clerk's office, you're saying are that matters in equity. We don't recognize what you're talking about in
You
these
asked,
filings.
this is a bank. This is a bank. I understand how the
What'd you
court-
say?
This court system operates like a bank.
Okay, it doesn't, ma'am. This
It
court system doesn't
operates.
operate like a
Yes, it
bank in any way whatsoever.
I
So,
hold on, let me finish.
no, I'm not gonna let you finish that
Okay.
particular
Like
statement.
I said, I want to
because
preface
I
this.
just
Don't
need-
want to argue.
I need you
anything.
to,
I just want you to
redirect it.
understand me mentally.
I did the mental thing just fine. I'm not
Okay.
worried about any mental thing.
Okay.
What I'm worried
okay.
about is the conception you may have that this is some sort of court of equity or some sort of a business transaction, some sort of a bank, something of that nature, because it is none of those things. You realize that? This is a criminal court.
Yes, it is. This setting is.
We're not an Article 3 court. That's a federal concept.
Yes.
You understand that?
Yes, I am.
Okay, we're an Article 7 court, if you must know, in the state of Indiana, separate judicial branch,
Yes.
not any of the things that you've said here.
Yes.
So what I need you to tell me is
Okay.
whether you are understanding that you have to follow, if you're going to represent yourself, you have to follow all the rules and regulations that are promulgated by the courts of Indiana. You have to follow the criminal rules. You have to follow the trial rules.
Yes.
Will you do that?
Yes. Yes. Yes.
You will do that.
Yes.
So you understand that what you filed yesterday can be stricken under the record. Under the trial rules, under Indiana Trial Rule 12F, because it's impertinent to anything that is going on in this proceeding. You realize that?
I understand that in a sense, but like I keep explaining to you, it was not supposed to be filed in the court. That's the difference.
You filed it at the clerk's office.
Yes.
Well, let's carry that out for a minute.
Yes. It's a difference.
What's the name of the clerk's office?
The court's office is the clerk of clerks. Clerk of clerks.
Clerk
Yes.
of courts, right? So there are
Yes.
clerks. So if you
Yes.
file something that, and you have a case pending, they send that to your case. Unless you try to open a case of your own,
No.
you're trying to open litigation of your own.
No.
Okay.
What I am.
This has to be presented in your court case here that you have pending before us.
Okay.
you're
So
telling
you
me
will
you
not
have to follow
strike
the
it?
Rules.
You won't strike it down or you will strike it?
Oh, it
down?
has to be stricken. It is impertinent to anything we're doing here. You understand?
No, I don't understand.
Okay.
how You
You
just
have
strike-
filed documents making commercial demands, demanding accountings,
Yes.
challenging the capitalization. No, you didn't do that, but challenging different things about who you are and who you would in equity
Yes.
minister to,
And for
those
me,
kinds of things. Ma'am, you understand those have no basis in Indiana criminal law.
okay,
You realize
But-
that?
but let me explain. Can I make a statement to you then? You said there's no basis in criminal
Go
law.
ahead. What's your statement?
What I also want to say something, and I am a minister, and I want to read this on the record, okay? And it states that should a man prove himself to be living and not dead, nor lost of sea, his estate must be returned to him with mean profit. I am the living man that has a womb. I have accepted appointment of this office of executive. As such, this office gives notice of its accusations and findings. And now I have issued orders, okay? And in the scripture, the living and the spiritual man judgeth over all things, yet he shall be judged by no man. And that's 1 Corinthians chapter 2, verse 15. Like I said, I came here with clean hands. And I'm now the executive. My estate has no longer been abandoned. And I don't allow no more trespassing and interloping upon and administrating it. I discovered a lot of things along the way, put me in this position.
Okay, ma'am. Clean hands is an equitable doctrine. You understand that? This is not a court of equity. If you were in a court of equity, you wouldn't even be given or afforded the right to a jury. I think it's appropriate for me at this time now to terminate the Ferretta inquiry, deny your request to proceed pro se. I'll specifically find that the request is not a genuine attempt to present a legal defense, but a calculated strategy to obstruct and subvert the court's proceedings. The defendant's utilizing rhetoric of what would typically be called a sovereign citizen movement,
No.
including raising nonsensical
No.
challenges
No,
and attempting to apply commercial law to criminal prosecution
no,
or equitable law.
no, that's not
Ma'am, you keep
true.
saying no, but you're talking over me and I don't appreciate it because I'm trying to rule. The right of self-representation is not a license to abuse the dignity of the courtroom or ignore relevant rules of procedure and substantive law. Based on the defendant's filings and her statements in open court, court finds she's unwilling to comply with rules of procedure and intends to use self-representation solely for deliberate disruption of the proceedings. The request to proceed pro se is denied and appointed counsel will remain on the case. We're adjourned.
Across both hearings, the pattern is consistent, language is being used as a shield, but it's not recognized by the system making the decisions. Terms like affidavit of status, living man, or equity feel powerful because they suggest independence from authority. But in a criminal courtroom, those concepts carry no procedural weight. The first defendant tries to force the court into proving jurisdiction through a private contract. That's a fundamental misunderstanding. Courts derive authority from statute and constitution, not mutual agreement. So instead of weakening the case, that argument removes any chance of negotiation and pushes the process toward a jury trial. In the second case, the defendant goes further, blending administrative claims, religious language, and sovereign-style arguments. But here, the consequence becomes more immediate. The judge identifies that this isn't just confusion, it's a refusal to operate within the legal framework. And that has a direct cost: loss of the right to self-representation. That decision matters, because once the court believes a defendant will not follow rules, it steps in to control the process, not as punishment, but to preserve the integrity of the trial. Both cases show the same turning point, when belief replaces strategy. And in court, belief doesn't set the rules, procedure does. And once that line is crossed, the outcome is no longer shaped by argument, but by compliance.